Constitution, Honorable Mr. Justice Sri Bhatt, Mr. Sri Suresh, other Vice Presidents, distinguished guests, ladies and gentlemen, and you have to forgive my accent here and pronunciation, Kalai Vanakan. So, I am honored to be here this morning, and I wish to begin that standing here as Chief Justice of Jamaica in a country such as India with such a rich history is a distinguished honor bestowed upon me by your association, and I do not take it lightly. Because you see, our countries have been linked for almost 200 years, where your ancestors began arriving in Jamaica in May of 1845. So after slavery ended in the British Empire, they had to solve the problem of getting persons to work on the sugar estates. So they came to India. And so that began now the connection between Jamaica and India, and they took persons from largely the northern states, believe it or not, largely the northern states, and some from this state here. And so they arrived in Jamaica on May 10, 1845, and they landed at Old Harbor Bay in the parish of St. Catherine. That's on the south coast, so when you have some time you can do a Google search, and there you will find the place where they landed. Now, when they came, they were told that the initial period was for 1 year, and then it was later increased to 5. So when the period ended, and they said, well, let us go back to India. The British said, well, we have no money to send you back to India, and consequently, just under 40%, that actually came back to India, and the rest remained in Jamaica, and they can be found in Guyana and in Trinidad. And so your ancestors now, they brought with them curry powder, rice cultivation, mangoes, jackfruit, tamarind. They also brought the skill of jewelry making, the distinctive music and dance, and traditional dress, which has been incorporated into the Jamaican culture. They also brought Diwali. And the Indian contribution to Jamaica's cultural and economic life is well documented. And so India and its peoples continue to make great contributions to this region, as the Asia-Pacific region and the world. And this conference is taking place at a time when India, by its recent experiences through litigation, largely through the last 5 years, has contributed much to the world, especially developing countries, as those countries seek to understand and develop effective strategies and mechanisms to deal with multinational corporations who seek to take advantage, but of course some might say abuse, of tax regimes to minimize their tax liability. And so I spent last evening since my arrival reading through 153 pages of the judgment of the Supreme Court of India, Civil Appellate Division, the judgment delivered by the Honorable Mr. Justice Arun Mishra, and it is a very significant case in the scheme of things, being only recently delivered on October 24, 2019. And so this case now is the Union of India against Association of Unified Telecom Service Providers of India. And then, since I have been here, I try to look into the newspapers as well. And I have observed 2 newspapers here. One is the Business Standard, and that is a Friday, November 15, 2019. And it has on the front pages here, voter idea takes 8-year hit, posts 50,921, assist me with crores. And that I understand that translates into somewhere about $500 million US dollars. $500 million US dollars, yes. And then the other newspaper, the Financial Express, also of today's date, Friday, November 15, speaks to 74,000 Trurek telcos loss, hit hard by Supreme Court's 8-year order. Bharti Airtel posts huge loss, of 23,045 crores. How's it pronounced? Crores in second quarter, and they have also referred to Vodafone. So this decision now has essentially set the cat amongst the pigeons. And now the conference is also significant because it is taking place in the context of what is called base erosion and profit sharing. And that has emerged as perhaps the most pressing taxation issue of our generation. And when I was looking at the literature, especially coming out of the OECD and from Europe, it is being presented as being grounded in the equitable concern that countries should get their equitable share of taxes from entities that are liable to pay taxes in a particular country. Well, I won't accuse the honorable men and women of not having these concerns, but I'm also a student of history, especially history of slavery, colonialism, and domination based on ethnicity and perceived inferiority. And it is always good to see if there are motivations behind what is being presented as fair and equitable. Because from my standpoint, the issue here is about money. It doesn't matter the language that we wish to use and how we want to dress it up. It is who gets the money at the end of the day. That is what this is about. So, I'm a West Indian. I'm a product of the legacy of slavery, colonialism, and so that is part of who I am, and I make no apologies for that. And so I can't forget, for example, that there are some who came bringing the Bible with them, which taught about God and love and respect for your fellow man and so on, but it did not prevent them from getting into slavery, colonialism, and domination of other ethnic groups. And so the Bible was preached on one day of the week, but the practice on the ground was antithetical to the very principle that was espoused in that day. And so from Africa there's an expression that when they came, the people had the land and had no Bible. And they were taught to kneel, close their eyes, and pray. And when they opened their eyes, those who came now had the land, and the people who were there had the Bible and no land. So what I'm saying then is that when we hear these discussions, we cannot ignore the lessons of history, hard and unpleasant though they may be. And the sad history of the colonial experience tells us that those who came to our shores and found us have never developed any scheme that benefited us more than it benefited them. So in this era then of increasing interest in reforming taxation at the international level, let us be aware of history, not to imprison us or prevent us from seeing that there's perhaps a real need for reform. What I'm saying is, let us not be naive. So it has been said that what is happening currently is perhaps the most significant overhaul of the international taxation system in the last 100 to 150 years. So let us translate that now. It means that in the last 100 to 150 years, most developing countries were colonies. So when these things were being developed, they didn't have us in mind. They had in mind the colonial powers. And since we were colonies, then naturally, whatever the colonizers decided, then we would be impacted by it. So this era now presents the opportunity not only for our voices to be heard, but also for our interests to be placed front and center of these reform efforts. So in preparing these brief remarks, I have learned that base erosion refers to a company, perhaps conceptually it could apply to high net worth individuals, who knows, using financial measures and tax planning in such a manner that it or his or her tax liability in any given country is reduced significantly. Again, it's about the money. Who gets what? Because when you're dealing with a company, if it's a company with shareholders, the dispute ultimately is going to be about, will the shareholders get more or does the government get more? That's what this is about. So the literature has been careful to point out that in many instances this type of tax planning is oftentimes legitimate and arises because of the different tax laws in countries. And these differences enable persons, natural and legal, to pursue their affairs in a manner that minimizes their tax exposure in what is called high tax jurisdictions. Profit shifting, I was informed, refers to the making of payments to other companies within a group of companies so that profits are moved from high tax jurisdictions to jurisdictions perceived to be low tax ones. The main motivation for this, I suspect, is to increase profits and presumably happier shareholders. So these payments, transfer pricing, I have been informed, may be royalties and interest payments, since these types of expenses can be deducted from pre-tax profits. Correct so far? Oh, good, see. I'm just a mere lawyer, you see, so I don't get into the intricacies of these things, but at least I got that right. And some jurisdictions, it is said, treat income from royalty more favorably than others. So again,